Morning, everyone. As Matthew says, I'm going to speak about the recently enacted amendments to the anti-money laundering regime in the British Virgin Islands, also known as the BVI, to digital assets. For those of you who are familiar with the BVI, you will be aware that it takes a very strict approach to compliance in relation to anti-money laundering, also counter-terrorist financing and counter-proliferation financing, also known as AML, CFT, and CPF, as you can see on the slide. And if you've engaged lawyers or other professionals in the BVI, or even if you have an investment fund that's established there, for example, you will, I'm sure, be all too familiar with the requirements. For those of you who aren't quite so familiar, the BVI's anti-money laundering regulations require that a relevant person that undertakes a relevant business, that they must carry out certain AML, CFT, and CPF obligations before they establish any kind of business relationship, or even before carrying out a one-off transaction with any third party. Examples of relevant businesses should now be appearing on the screen, and the extent of those perhaps won't come as much of a surprise to you. And as you can see, they include operating a business such as a banking business or a trust business, insurance business, investment business, or including a mutual fund, a financing business, a real estate business, which would include things such as a real estate brokerage, and even certain professional businesses such as attorneys, notaries, accountants, and businesses who provide registered office services. And a relevant person is simply someone who carries on any of those relevant businesses. Crucially, a relevant business did not previously include what you might call virtual asset services, and a relevant person did not include a virtual asset service provider. That is until now. Under a new piece of legislation that has been enacted in the BVI, called the Anti-Money Laundering Amendment Regulations 2022, and also the Anti-Money Laundering and Terrorist Financing Amendment Code of Practice, a relevant business now includes the business of carrying on or providing virtual asset services within the meaning of the Virtual Asset Service Providers Act. And that's where a transaction involves virtual assets that are valued at $1,000 United States dollars or more. These provisions, whilst they are currently enacted, they don't actually come into force until the 1st of December this year. You will have noticed my reference just now to the Virtual Asset Service Providers Act. Some of you will understandably be thinking that there is no such legislation in the BVI, and for now you are quite right. Whilst not yet in force, the BVI has very recently published a draft version of this legislation, and so we are able to see how virtual asset services is likely to be defined. In the BVI, the providing of virtual asset services includes providing any of the following, and they include exchanges between virtual assets and fiat currencies, exchanges between one or more forms of virtual assets, any transfer of a virtual asset on behalf of a third party, and which involves moving that virtual asset from one address or wallet to another, any services that involve the safekeeping or administration of virtual assets, such as the hosting of wallets or maintaining custody or control over a third party's virtual assets, wallet, or private key, providing any kind of financial services in relation to the offer or issuance of virtual assets, such as ICOs, and even things such as running kiosks for enabling virtual asset activities or transactions to be undertaken. The drafting, therefore, as was perhaps expected, very similar to the definition of virtual asset service provider that's published by the Financial Action Task Force, or FATF, as Matthew mentioned in his original introduction. And it's therefore, for those of you that are familiar, broadly similar to the equivalent definition that is already in force in the Cayman Islands. It will therefore come as no surprise that the definition of what constitutes a digital asset also tracks the FATF's recommended wording, and is defined as being a digital representation of value that can be digitally traded or transferred and can be used for payment or investment purposes. The draft legislation also includes some additional AML requirements. In section 25 of the draft legislation, subsection 2 requires VASP to, in addition to its other customer due diligence obligations, to adopt measures that assist it in matters such as tracing and collecting the IP addresses of its customers, their geographical location, the type of device that they're using, virtual asset wallet addresses, and even transaction hashes. You might be wondering why these changes have been introduced, and the answer again relates to the FATF, who require that VASPs worldwide be regulated for AML CFT purposes, and that each jurisdiction introduces its own registration and licensing requirements that meet the FATF's strict recommendations. So what does this actually mean in practice, and what are the practical implications of this change to VASPs in the BVI? Well, this means that VASP will need to comply with the following from the 1st of December this year. They will need to have appointed a money laundering reporting officer, or MLRO. In this case, an MLRO must be a natural person. So, for example, it cannot be a company or another type of corporate entity. This person must be sufficiently senior to perform the role of MLRO, and they must, of course, have access to all relevant information within the business to allow them to carry out that fully and properly. Secondly, each VASP will need to establish and keep internal reporting policies and controls relating to their customer identification procedures and the verification of the client due diligence that they're provided with. They must also carry out fraud, sanctions, and other screening searches as part of their onboarding process. They will also need to have sufficient procedures in place to ensure that all employees know how and to whom suspicious activity should be reported. And this belies the standard of training that all staff within the organization will need to have the benefit of on regular intervals. And thirdly and finally, they will need to establish procedures to enable compliance with what we are referring to as the travel rule in the context of transferring digital assets. On this rule, the FATF requires each country to collect information that identifies the transferor and the transferee in the context of national and international wire transfers. This is so that AML, CFT, and CPF audit trails can be properly established and, if necessary, followed and traced. In practical terms, this requires each VASP to obtain and to retain information relating to the transferor and the transferee of digital assets. They must report suspicious activity to the relevant authority in a timely fashion, and in certain circumstances, they must also take steps to prevent transfers from taking place at all where they involve certain prohibited persons and entities. This concludes this part of the webinar, which I hope you found useful, and I'll be very happy to take any questions towards the end.